Hello, good morning, everybody. How are you? I do hope you're all well. Thank you for joining me again today. Thursday mornings come around rather quickly. So today we are going to be talking about deposits. There's a fair bit of information today. So if you wanted to grab a pen and paper, please do so. And yeah, you can take some notes. But of course, hopefully we can get this webinar to you as a watch again. So do keep your eyes peeled for your email when it comes through. To let you know how you can watch that again. Just briefly, a couple of thank yous. Obviously, I've spoken to a few people in the last week. Mrs. Bateman, thank you very much for getting in touch, and I'll get those recordings to you as soon as I can. Hope you and the family are well. And Svetlana and Linda, thank you very much for getting in touch. Had a lovely chat with you, Linda. Thank you for your lovely words about the team in Putney, specifically Lee. Our Putney leader over there, our Putney manager, and Svetlana, your kind words about Rory over in Barnes, again, our Barnes manager. So really pleased to hear that our managers are impressing you guys. So without further ado, let's begin. And I'm going to share my screen with you. So I'll say bye for now, and I'll see you at the end. So here we go. It's time for tenant deposits. So what we are going to do today is I'll take you through the basics again, just to recap on that, just in case you're unsure of anything. We will look at some common claims that are made when it comes to negotiating the return of your deposit, and also when it goes to dispute, which hopefully your tenancy doesn't do. We don't want the deposit to go to dispute, really. And again, I'll show you some adjudicator insights to get an understanding of why when there is an adjudication made, the reasons behind it and how they reach those conclusions. So I think that's important, because sometimes when I talk to the team, especially the property managers, about their week and what's been going on, and often, you know, sometimes when those adjudications come back, sometimes landlords and tenants are a bit not disappointed, but they don't always get the result they want. So if I can explain to you as landlords how this process works, then at least in terms of your expectations, they're in a much better place when it comes to negotiating your deposit return. So let's go. As always, here's some extra information for you. You can go to the government website for information on deposits and landlord schemes. There's a couple of schemes here listed for you. There are many out there. There's quite a few. So, you know, feel which one you feel best suits you. If you are registering your own deposits. At James Anderson, we use the tenancy deposit scheme. So what this means is that the information I'm going to give you today simply means that this is to do with the TDS, the tenancy deposit scheme. If you are a member of the other schemes, then, you know, stay with us. The advice I'll give you, I hope, translates across all the schemes. However, if you do have an issue with your deposit and you're with another scheme, I do advise you to go to that scheme, just for the simple reason that there may be some nuances that are slightly different. So today it's all about the tenancy deposit scheme. So just a quick recap then. You need to protect your deposit for all assured short hold tenancies. These are often called ASTs in the industry. From 2007 onwards, it was law that you had to protect your deposit. I think, you know, most landlords know this already, but obviously our friend the Tenant Fee Act in 2019 said that deposits have to be 5 weeks or 6 weeks of rent. So those of you that were on the Tenant Fee Act webinar, hopefully there's a few thoughts coming back as to, you know, that 5 week or 6 week deposit and the £50,000 threshold. There are exclusions. Company lets, annual rent that exceeds £100,000 becomes a non-housing act, so it won't be covered by this legislation, and holiday lets and student lets will be excluded. Let's look at the legal side of things quickly. Obviously it's all governed by the Housing Act 2004, and there's been various amendments along the way, 2007, 2011, 2015. But I don't want you to get too bogged down in that. If you want to go and look it up word for word, please follow the links to the government advice. But this is really practical, sensible, you know, advice that I want to give you. I don't want to get into the realms of too much acts and things like that. So First and foremost, protect your deposit within 30 days of receiving it. That's the first thing you need to do. The next thing, provide the tenant with what is the TDS leaflet. Third, provide the actual deposit certificate. And then the fourth thing is provide prescribed information. So a lot of this is just about the documentation. And at this stage, this is the setup of the tenancy. We haven't even got towards, you know, the end of the tenancy and handing the deposit back. This is all pre-tenancy. Now, prescribed information, I guess you've heard that mentioned a fair bit, but what is it? And I just wanted to clarify this for you. So prescribed information, this is really simple stuff, but with a lot of the deposit legislation and compliance, it's very simple, but there's just lots of bits to it, and sort of a checklist to go through at each stage. It's not difficult, it's just got a bit of volume. So prescribed information, it's the contact details of the landlord and tenant, the actual address of the rented property, the deposit amount, and the provision of the TDS leaflet that we talked about. And it's got to also reference to the tenancy agreement the relevant clauses that say what happens with the deposit. Likewise, this has to be given to the tenant so that they can check it and confirm it, and obviously their signature on that document will confirm that for everybody. But the prescribed information is just as important as the actual logging of the deposit itself, because as always, there are penalties for landlords and agents that don't comply. Now, in the case of non-compliance, your tenant could take you to court. Now, obviously in the modern era, there's far more information available to tenants. Tenants know a lot more about their tenancies, and they're far more engaged with their tenancies, I would say. Obviously, they've been given the how to rent guide and what is the TDS leaflet. And in there, it explains all this to them. It tells them what your obligations are as a landlord. And also it mentions about if things haven't been done properly, this is how you can respond to that. So a tenant could take you to court if you have not registered your deposit within 30 days of receiving it. Now, on a good day, the courts might say, well, okay, landlord, you've just got to repay the deposit, or you've got to protect it immediately. Now, that's a good day when they're feeling pretty generous. What they could do as an alternative, or in addition to, is the tenant might be entitled to compensation, and that is up to 3 times the amount of the deposit. Now, I've got a rough idea of what the average deposit is in the areas that we work, and 3 times that amount is a pretty hefty sum. You're looking at several £1000s. So, you know, it's a bit of a mistake to make not registering the deposit. Equally, notice can't be served. We did the Section 21 webinar, so we know all about that. You can't get possession of your property without having the deposit registered. And also the prescribed information, there it is again, there's a 30-day rule there. From receiving the deposit, prescribed information has to be provided within 30 days. And once again, the tenant is able to clobber the landlord with 3 times the deposit amount for non-compliance. That is what the courts see as suitable compensation. So, you know, you're going to have a pretty bad day at the office if you get nailed for both of those and you failed in your duties. That's a lot of money to be hit twice because they're 2 separate documents. And remember, this is all through the courts. At this stage, the TDS have no involvement because there is no TDS. It hasn't been logged with the TDS and protected. So this is all court action. Now, there's a few things that you need to be aware of and remember. Before we get into the end of the tenancy and you know, talking to your tenant about any costs and damages or anything like that, the first thing that you need to be aware of is the relevant person. And that person is the person who's actually paid the deposit by definition. And this is important for everybody for the simple fact that you need to serve all the documentation that you serve to the tenant to the relevant person as well. So it might be the tenant that's paid the deposit, and that's absolutely fine. But it might be a parent where the tenant might be first-time renters and the parents have helped them out with the deposit. And it could also be student accommodation. Or in some instances, the local authority might have paid a deposit where the local housing authority has put a tenant into the property through one of their schemes. Either way, they need to be treated like they are the tenant. So you need to serve prescribed information. You need to serve what is the TDS leaflet, and you need to serve the TDS certificate to the relevant person as well. I hope that's all clear. Next up is the burden of proof. Now, this is more to do with if you get into a dispute or if you want to claim any costs from the deposit with your tenant. The onus is very much on the landlord to provide and prove their legitimate claim. Okay, it's the tenant's money, don't forget. So there's no obligation on the tenant at this stage. You know, if you're going to discuss it's their money, so you've got to really come with a solid case and everything you need in order to back that up. And in backing that up, you need your documents on the far right hand side there. I guess this is obvious, I hope, but things like, first and foremost, you've got to have a tenancy agreement. It might seem a daft thing to say, but no tenancy agreement, then the tenant has no rules to abide by. So I guess it's pretty much going to be a non-starter in trying to prove any claims or costs. Also, you need your check-in report and your check-out report. These are vitally important. This is what the adjudicators will look at to compare condition at start and end of tenancy. And the independent third party bit is really important as well. They look very kindly on independent inventories and check-ins and check-outs because they are independent of the landlord and tenant. And there's usually photos, and they're very comprehensive in these reports. Compare that to a report that a landlord has made themselves. You know, it might be a few pages of typed A4 and various items on there. You know, that is not going to really excite the adjudicator and compel them as much as a full, proper checkout document or check-in document from an independent, professional, third-party inventory company. Invoices and receipts are really important if you're trying to claim any costs. And of course, supporting evidence like videos and photos are really important as well. If you can have photos that are date stamps, that's even better, especially if it comes down to decor works and things like that, or any damage that you need to, you know, have further evidence of. So when you come to the end of your tenancy, hopefully we've got the first instance, everything's fine, and there's an agreement between the landlord and tenant, and the deposit is returned. Hopefully that's the full deposit and you've had a really good tenancy and everybody finishes and off you go and you move on to the next tenancy. There might be some deductions, but if they're all amicable, then that's absolutely fine. The other side of it is when an agreement can't be reached between the landlord and tenant. So if that is the case and you have tried your best, but there's something that just can't be overcome, after 10 days of the tenancy ending, the tenant can then apply for the tenancy deposit scheme to get involved and resolve the dispute. So really, you have 10 days to try and organise things and get them agreed and obviously return deposits. And this is totally feasible. There are very few tenancies that do go to the dispute service. We do try and keep those numbers down. Certainly for our full managed landlords, our team try very, very hard with negotiating with tenants and landlords to make sure that they don't go to the dispute service. There's a number of reasons which I'll go into, time factor being one for sure. So wherever possible, it is advisable to reach an agreement with your tenant. Try and keep those relationships rolling. You know, if you've had a good relationship, just be careful that that doesn't get soured at the end of the tenancy by a stalemate. You know, there has been instances where people are arguing over very, very small sums. It ends up going to the TDS, and actually the landlord would have been far better off just allowing the small sum because actually the TDS ruled far larger sums in favour of the tenant. So yeah, sometimes that can happen. Now, if it does need to go to dispute, this is the process. So the tenant asks the TDS to resolve the dispute right at the top of the screen there. So coming round to the right-hand side, so the deposit holder, whether that's landlord or agent, has to send the disputed amount to the TDS. The disputed amount, let's use this example. The deposit is £1,000. You're disputing a cost of £200 with the tenant. So there's £800 that is undisputed. The £800 goes back to the tenant as soon as possible, and it's the £200 that goes to the TDS. So the TDS will then ask the landlord and agent to respond within 10 working days with all their evidence. After that 10-day period, there's no more evidence that could be submitted. Following that, the tenant will then be asked to submit their evidence, and they have 10 working days to do that. Once that's passed, the TDS can take up to 28 days after the receipt of evidence deadline to make their decision. Following that, within 10 days, payment will be made to the appropriate party or parties. So already, you know, in terms of timescale, you try not to go to dispute. Look at that, it's 10 days after the actual end of tenancy, 10 days for landlord evidence, 10 days for tenant evidence, 28 days for the TDS to decide what's going to happen, and then 10 days for payment. So it's 2 months and beyond before anything gets resolved. So, you know, do you really need that added worry? You know, think about the tenant as well. If they're going into a rented property again, they would have had to find another deposit, another month's rent up front, and this deposit money coming back to them could be really important. So yeah, do think long and hard before you do go to dispute. And by the way, if the tenant does lodge a dispute and the landlord does not respond, the TDS consider that as consent to continue with the dispute. So, you know, by staying quiet and not doing anything will not stop anything. It will keep rolling ahead. The only thing is you will not have any evidence on your side. So therefore, the adjudicator can only make a decision based on the evidence they have. And it's likely that it won't go your way. So there is no hearing with the TDS as such. There'll be no property visits or anything like that. It's all based on the evidence that's submitted. Their decision is final in terms of how monies are given to each party, and there's actually no appeal either with the TDS. So again, do think long and hard before you decide that the dispute is the only way around this. So here are some common claims that we often see. So let's say we've gone through the tenancy and now we're looking at trying to claim some costs, you know, from the tenant, and whether these are things that you negotiate or whether, you know, this is a bit more of an insight into how the dispute service look at things. Do bear this in mind, because this might really help you, especially if we don't manage your property and you deal with the tenant yourself. Some of these points might just really help you get the right information and the right figures if you are going to try and claim something from the deposit. So before we start any of these, you've got to have your tenancy agreement. Again, I keep mentioning that, but sometimes on the odd occasion, I do get a phone call or an email from a landlord and they can't find it. You know, it wasn't our agreement that we provided, it's their own, and really there's nothing I can really do to help in that instance. So let's start with cleaning. What you're going to need is a signed checkout report and a signed check-in report to start with. If you don't have that, there's nothing that can be compared by the adjudicators. You know, your tenant will pick up on it, and it might be very, very difficult to claim anything against cleaning. Signed periodic inspections will be handy. Invoices, receipts, quotes, like we've said before, they're going to be vital as well in terms of costs. Photos and videos, like we've mentioned. And also any correspondence, emails, records of phone calls that you've had with the tenant regarding cleaning. Any discussion is going to be looked at as part of this process. And when you're negotiating with the tenant, you can refer to those and refer to any agreements you might have made. When it comes to adjudicators, they're going to think about the size and type of property regarding cleaning, you know, and what the tenant is actually liable for. They might have done some cleaning And the extra cleaning required by no means is a full clean in terms of a professional clean that might be several £100s. So you've got to really think about what the tenant is required to clean. And remember, with the cleaning, the tenant's obliged to return the property to the same standard in which they received it. So that's where a really good check-in report that's been signed by the tenant and by the landlord is going to be very important. Damage to property and items. As with cleaning, check-in report, check-out report is really going to be what is going to help you on this front. And again, inspections, invoices, if you're trying to claim any money. And is it proportionate to the actual repair or damage, what you're asking for? Do make sure that you're being fair in that sense, because a tenant will push back. They know they've got the TDFs to fall back on. Gardening, as before, check in and check out, all the things like that are important. In the contract, it says the tenant can't lop or prune any trees and bushes, etc. But they are responsible for mowing the lawn if they've got a private garden and keeping the garden in reasonable order, or what we call seasonal order, depending on the time of year. So photos are going to be really important here of the garden before, after, and again, if the tenant's made any requests to trim anything in the garden and you've agreed to that, I would want to see a photo of its current state, and then also a photo once the work has been done by the tenant, just to be absolutely clear. Outstanding utility bills. Now this is quite easy because obviously we hope that there's a copy of the bill in the first place and that it's in the tenant's name. It is a tenant's responsibility to pay for the utility bills if it says so in the contract, which the vast majority do. It's also the tenant's responsibility to have their name on those bills. So hopefully this may not even come into the deposit dispute or even into your negotiations, because if the tenant name is on there, then that debt is to the service provider, not to the landlord. So non-payment of rent. Again, you might be able to show some bank statements of rent coming in, and then obviously those months with missing rent. That is good, but what is more compelling to an adjudicator is a full statement of account. That's what's really going to get their attention. And this is going to be really important. So again, make sure you've got that, every rent that's been paid or missed. Make sure the tenant is aware of this as well. You've got to show evidence that you've made the tenant aware and that they've had time to comment about non-payment of rent. Now, wear and tear, I've left this to the bottom of the list, not because it doesn't come up as often as the others, but it's a bit of an interesting subject in the sense that, expectations of wear and tear do vary, obviously, as you can imagine, and what the interpretation is. So I've looked at the House of Lords, and they said their definition of wear and tear is reasonable use of the premises by the tenant and the ordinary operation of natural forces. So really, it's sort of the day-to-day use of the property. Obviously, the word reasonable can be interpreted differently depending on the type of property and who occupies it. Something to be aware of, in addition to this, it's kind of an established principle that a landlord is not entitled to charge the tenant the full cost for having any part of their property or any fixture or fitting put back to the condition it was at the start of the tenancy. Landlords should keep in mind, therefore, that the deposit, it shouldn't be used like an insurance policy where you might get full replacement value, for example, or new for old. That's not how it works. As a landlord, of course, you've got a duty to act reasonably and not claim more than is necessary to make good any loss that you suffer. So, for example, with adjudication, they might look at it in a number of ways. So replacement of a damaged item might be justified where either it's severely damaged or extensively damaged beyond economic repair, or it's just unusable. That's when replacement might be considered. Repair or cleaning is probably more likely where a replacement can't be fully justified by the adjudicator. So repair in place of replacement. And in some cases, it might just be that the value of an item has decreased or the lifespan has been shortened by damage of one sort or another. This might be considered as a compensatory award to the landlord from the tenant. That might be appropriate. So there's three things there: replacement, repair, or compensation. So when we're trying to find a remedy, it is said that the landlord shouldn't end up financially or materially in a better position than they were at the start of the tenancy, or you know, due to fair wear and tear, and or that they're in a state of what is known as betterment. So if I can explain that, let's use a carpet as an example. If the carpet was brand new at the start of the tenancy, let's say the tenancy lasted 2 years, then it's a 2-year-old carpet at the end of the tenancy, of course. If it was damaged beyond repair, and then the landlord was claiming the full cost of the carpet, that's known as betterment, because the carpet's 2 years old. So therefore, the full cost of that carpet can't be claimed. I will show you a calculation that might help you understand that a bit better in a few moments. So in order to avoid allegations of betterment from your tenant, when you are trying to claim monies, and especially this is how the adjudicators will look at it once if it goes to the dispute service, when making an award, the adjudicator will take into account the items such as wear and tear, what is the most appropriate remedy, repair, replacement, cleaning, or a compensatory award, and also betterment. You know, and if there's evidence of the landlord trying to seek betterment, I don't think that is really looked upon too kindly. And although this is all advice, and I hope that this is good, sound advice for you, it's really difficult to actually give strict guidance and defined guidance on the value of deductions that you can make from a deposit. There are so many factors involved and so many variables that it has to be a case-by-case basis. It really does, and take each case on its merits, because no two cases are the same. And some of the reasons, you know, behind that are, you know, the adjudicators will have a criteria that they look at. So let me just show you a couple of bits that I hope might just give you a bit more insight into how your deposit dispute is looked at. So the length of tenancy. The longer the tenancy is, of course, the more wear and tear there will be. That's kind of common sense. But you know, how much wear do you get on your own carpet in your own house? Have a think about that. And what does a new carpet look like after 2 or 3 years of use? And what was the condition when the tenancy started? Was it brand new, or have you had several tenancies come and go? So, you know, think about that. What about how many occupiers you have and who they are and the ages? The more bedrooms and occupants you have, the more wear and tear that's got to be expected in common parts like your sitting room, hallways and landings, kitchens. So if you let to a family, think about that. You know, I live here, it's just myself and my girlfriend, there's 2 of us, but, you know, inevitably we've got a few scuffs and scrapes. It's our own house, so, you know, we'll deal with that. But in a rental property, scuffs and scrapes are unavoidable, especially with family life. You know, a property occupied by a single person, you would hope, is in far better condition than a house with a family. So quality and condition as well. You know, what condition is the property in the first place? It would be unreasonable for a landlord to provide a really cheap, flimsy set of bedroom furniture and then blame the tenant when the items are damaged through normal use. You know, and also think about the actual fabric of the property itself and the quality of that particular item. So, for example, what about new builds? A lot of new builds aren't quite as sturdy and robust as old properties or conversions. So things like walls, partition walls, suffer a bit more stress and potentially higher footfall. And so that means that there's a greater need for redecoration at the end of the tenancy, for example. So yeah, you know, do be aware of that. Wear and tear, again, we've kind of covered that. And so just avoid the betterment side of things. And awarding sums, I hope that there's been a little insight into how sums are awarded. It is proportionate. So do remember that. Let's say one example is a kitchen worktop. I can understand as a landlord, if there's damage to a kitchen worktop at the end of the tenancy, you want to replace that whole thing. However, the adjudicator will award sums in recognition of damage which has occurred. And And even if it's admitted by the tenant that yes, they did cause that damage, to replace a whole worktop at the tenant's cost, they will just see that as unfair. And so there would be perhaps a proportion of that cost that the tenant would need to pay. It probably wouldn't be the full cost. Okay, so here's a quick calculation for you. Let's use a carpet as an example. So the cost of a new carpet is £500. The age of the existing carpet is 2 years. The average lifespan of a carpet, let's say, is 5 years. So the residual lifespan of the carpet is 3 years. Let's look at it like that. So the carpet will depreciate somewhat. So if you take A, the cost of the replacement, divided by C, the lifespan, so £500 divided by 5, that gives you £100 per year in terms of that carpet. I hope that makes sense. So when we look at part D, the residual lifespan, which is 3 years, and the value of what 1 year represents on that carpet, so D times E, that gives a reasonable apportionment, which is £300. It's a very simple calculation, but I hope that is useful to you. And again, there are some similar formulas that they will use for redecoration costs and things like that. Now, these aren't hard and fast rules, like I said. And the adjudicator can only work on the evidence that they have in front of them that has been submitted. So if that leaves the adjudicator's reasonable view, as we've mentioned, and that word reasonable, towards this method, then they will probably use that. But you know, it's not a guarantee. They can only work with the evidence that they have. So that's where the sort of deposit sort of stuff finishes here in terms of those insights. So I hope that's giving you some extra information to work on when it comes to returning your deposits. Hopefully they just get sent straight back. There's no issue. But if you are talking deductions with your tenant, this might be very useful. Now, how have things changed with deposits and COVID-19? Obviously, we can't ignore that. You know, some weeks ago, this landscape was a bit different, as you can understand. But at the moment, check-in and check-outs do seem to be going ahead quite successfully. There's the odd occasion where, you know, a tenant isn't that happy to have someone to do the checkout, but we're trying to work around those at the moment. So, but really the main thing is that if there's any delay to your checkout, then obviously there's going to be a delay in the deposit return. So in that instance, then really you're going to have to just get an agreement between you and the tenant in writing, get a compromise and discuss it with your tenant and make notes of that. It might be that, you know, if the tenant does vacate, you could go and have a look at the property perhaps yourself if you manage the property. But if you're not happy to do that, maybe the tenant could walk around and do a video for you. They could do that on WhatsApp or something like that, or a FaceTime call. And you could say, look, can you show me this room? Can you show me that? Can you open the cupboards? You know, and you can satisfy yourself to quite a large degree of the condition of the property. So yeah, that's what I would recommend doing. Rent reduction. If you've reduced your rent for a tenant during COVID-19, can you claim that any missing rent at the end of the tenancy? What you need to do is think about what your agreement is. Is it deferment or has it been written off? If that payment is deferment, then fine, yes, you can take that from the deposit and claim back the arrears. That should be okay. If that money was written off, then no, you can't. So just think about what you've actually agreed with your tenant. What if you've reduced your rent and that is ongoing? And you said for the rest of the tenancy, your rent will be X amount at a reduced rent. That is going to affect your deposit because the rent has been reduced and your 5 or 6 week deposit needs to reflect that. So if you have reduced that, you've got to look at the deposit. You have to, because you're going to have to re-register that deposit at a different amount, and you've got to go through the process of serving all the documents again, okay? If you want some help with that or you need further clarity, do get in touch with us. Non-payment of rent, can that be taken from the deposit? Yes, it can. So if that's the situation you're in, you should be fine to do that. However, my advice to you is deposits should be for damages, cleaning, and then rent arrears, and in that order. So before you agree to anything with your tenant about money coming from deposits for rent, make sure you know the condition of the property. Don't get caught out, because if you've got damages and cleaning to do, you may not be left with much money for arrears. Property inspections. Again, video technology is going to be our best friend on this, with tenant assistance as well, obviously these midterm inspections. And you know, reports will still be produced. They might be a little bit slower than previous, but we will keep you informed of anything that's going on at your property at all times, especially with the property inspections, because we do see those as very important in our process. So the advice I can give to you: communicate, keep an audit trail, and use common sense, especially where you've had an issue regarding COVID-19 and your deposit. The best thing is your records. Keep those. Keep your records. That is one of the best things I can advise you when it comes to agreeing things with your tenant. So if we're going to take things away from today, here's a number of items that, if you've got these, you should be in a really good place regarding the end of your tenancy, returning your deposit to your tenant, and also if you are going to go to the deposit scheme, this is what you need. So, tenancy agreement, check in, check out reports, periodic inspections. If there's any changes mid-term, if the tenant's done any DIY, if you've replaced any appliances, if you've done something for the tenant or installed something, fixtures and fittings, have a record of that so it all ties up at the end. Invoices, receipts, estimates, quotes, they all need to be there. Date stamped photographs if you can do it, and videos, copies of correspondence, witness statements if that applies to the situation, and avoid betterment and be reasonable in your claims, okay? And again, it's a case-by-case basis with the TDS. Different properties, different tenants, length of tenancy, they're all taken into consideration. If you want to ask anything more, you can speak to me. I'd welcome all calls and all emails. You can speak to your property manager or your branch manager as well, if you wish. And what I'd like to say really is thank you for everybody who has contributed so far and asked me questions. I really, really enjoy those. Do come to me if you've got any queries at all. I'll do my best to help you if I can. If I can't, I'll try and point you in the right direction. So next week, it's right to rent. We're going to recap over that and just make sure that everybody's in tune and happy with that. So I hope today's been a good experience and you've learned something. We'll get the recordings out to you very shortly. And yeah, stay safe, keep looking after each other, keep talking, and I'll see you all again next Thursday. Thanks very much. Have a lovely afternoon. Bye.